Hi, I'm Professor Mark Grabowski, and this video lecture will cover laws that public relations practitioners should know. First, let's begin with a story. Imagine this. It's commencement. You're graduating from college. Your family's there. A college photographer snaps a photo of you and your mother. It turns out really well, and the college's public relations people decide that it would make a really nice addition to a brochure they're working on. After all, a picture's worth 1,000 words. Not a big deal, right? Assuming you're not having a bad hair day, of course. Well, it could be a big deal. This same situation basically happened 10 years ago at Lafayette College in Pennsylvania. A student sued after he had his photo used in a school brochure on financial aid. You see, the student had not received any financial aid. He sued for invasion of privacy, unauthorized appropriation of image, and portraying him in false light. It wasn't just a big legal mess. It was also a big PR mess. You see, the student was black and felt the school had reinforced old stereotypes by printing the photo. Although the student's father was at the graduation, the photo showed only the student and his mother, and it appeared in a financial aid brochure, even though the student's parents paid the entire six-figure price tag of a Lafayette education. The photo sort of suggested here was this poor minority student from a single-parent family, when nothing could have been further from the truth. Eventually, after 5 years of litigation and bad publicity, Lafayette issued an apology and settled out of court for an undisclosed amount. While this example is a bit extreme, it underscores the importance of why PR practitioners need to know the law. We live in a litigious society where all of us, including public relations practitioners, must be concerned with protecting our own work and avoiding any conflict that would result in legal action against us. Unfortunately, the trend toward frequent legal action in our culture forces all practitioners involved in public communication to know the laws that affect their profession. So today, I'm going to give a brief introduction to those legal principles that affect the practice of public relations in the United States. Because of the short amount of time we have, I will discuss only general principles that can be used to guide you in public relations. First, let's discuss copyright law. We previously covered this in class, so I won't rehash it in great detail here. But as a PR practitioner, it's critical to understand copyright. Basically, copyrights protect only intellectual property that has been reduced to a tangible form. In other words, neither one's ideas nor those of a client for a press release or campaign can be copyrighted, but the written notes, photographs, printed verbiage, and recordings can. In public relations, things that are typically copyrighted include articles, stories and opinion pieces, newsletters, brochures, videos, advertisements, musical works and lyrics, artistic works, websites, both the content and coding of websites, and if you use someone else's work, you need their permission unless they state otherwise. For example, many photos on Flickr.com just ask that the photographer be credited, not compensated for the picture, or unless your work is covered by one of the fair use exceptions, you need permission. Print news releases and other public relations materials aimed at the news media generally are not copyrighted because they are meant to be used without restriction. Additionally, facts can't be copyrighted, so things like calendars can't be copyrighted. Well, the photos in calendars could be, but not the dates. Another important area for PR practitioners to be aware of is the law surrounding hiring freelancers. PR firms often hire freelancers to assist with various projects and campaigns. For example, very few small companies can afford to keep an artist or a photographer on staff full time. if your company wants to design a new logo or have photos taken for sales materials, you'll probably have to hire a freelancer to do it. You should recognize the distinction copyright law makes between original works, which are those owned by an individual author or artist, and works for hire, which are those owned by an organization that pays the author or artist either as a salary or as a commission. The law presumes that an employer owns the copyright to artistic or creative works produced as part of an employee's job performance. This presumption affects people who work in PR either for an agency or an organization. However, freelancers are not considered employees unless a contract specifically identifies their creations as works for hire. Otherwise, it is presumed that freelancers give a publisher only one-time rights and retain copyright ownership in their own name. The next trouble spot we're going to discuss is privacy. Celebrities aren't the only people who have laws protecting the use of their image. Non-celebrities are also protected if the use of their info or images causes them significant stress. What this means for PR practitioners is that you need to be careful with newsletters, photo releases, product publicity, advertising, media inquiries about employees, things like that, because while giving basic information such as an employee's name and title is okay, beyond that you need to tread lightly. You could get in trouble. It could be deemed an invasion of a person's privacy if you give out any information beyond that. The good news is that there are ways to work around this. You can protect yourself from liability by getting employees to sign waivers. For example, they might sign a sheet that says, yes, I give the company permission to publish a profile about me in the newsletter. Another thing you can do is have employees fill out a bio sheet that can be shared with the media and that contains information, beyond just their name and title. Make sure you get written permission and not just verbal permission. While verbal permission is adequate, it's harder to prove that you did in fact get someone's permission verbally. But obviously if you have a document with their signature, that's going to stand up a lot better in court. Keep good files. Remember Lafayette College's blunder? If you don't provide correct details about a file photo, you could end up in a similar situation if you use the photo later on. Or I should say, if you misuse the photo later on. And remember, minors can't give consent. You need to ask their parents for permission. Now let's discuss defamation. Defamation is also known as slander and libel, and these are false claims that hurt someone's reputation. Now, this is more of an issue for journalists, although public relations materials such as internal newsletters and employee magazines can be the basis for libel lawsuits. If you are sued for defamation, the only defenses courts have allowed public relations firms to use is 1. It's not a lie, it's the truth, and 2. Fair comment. Unlike journalists, you cannot rely on the news gathering defense in public relations. Usually, though, when it comes to defamation, public relations practitioners tend to be their own worst enemy. If you do a really good job promoting your company and CEO, for example, you could make him a public figure by legal standards and thus have a much harder time winning a defamation lawsuit. So someone like Dallas Mavericks owner Mark Cuban or Microsoft founder Bill Gates would have a much harder time successfully suing someone for libel than the owner of the bagel shop down the street. Okay, next up in our list of trouble areas is the topic of conspiracy. If PR practitioners provide advice or tacitly support an illegal activity of a client, they can be held liable for conspiracy. Offenses include bribing a government official, covering up information that's in vital interest of public health or public safety, or creating a front group to hide connection to a public relations firm or a client, among other things. In 2006, you may recall, a prestigious public relations firm was publicly embarrassed when it was revealed that it was responsible for writing a blog about Walmart. The public had initially been led to believe that the blog was written by random consumers. Be aware, even if you're an entry-level employee with no authority to call the shots, you can still get in trouble with the law when it comes to conspiracy activities. Now, of course, not all PR practitioners work for PR agencies. A number of corporations have their own PR departments as well. So if you work in-house for a corporation, familiarize yourself with federal securities laws. Basically, the laws hold that full information must be given on anything that might materially affect a company's stock. It must be timely, meaning within minutes or hours, not within days or weeks. So cover-ups like what happened at Enron are illegal. Also, insider trading is illegal. As a public relations practitioner, you may be privy to top-secret information, such as a merger between two companies. You may have to write a press release on it, for example. When mergers happen, stock prices usually go up. It would be tempting to invest some money in your client's soon-to-be merged company, but it's illegal. It's also illegal if you suggest a friend should do this. Martha Stewart learned this lesson the hard way. Now let's discuss confidentiality. You have none, legally speaking. While public relations practitioners are expected to maintain confidences and private information about their clients, they can't claim privilege at a legal proceeding. If a prosecutor puts you on the stand to testify against your client or your supervisor, you are legally obligated to do so. Beyond the aforementioned mass communication related laws, every public relations professional should also know the laws that govern his or her organization and industry. A practitioner in a hospital, for example, should have an understanding of managed care and its ramifications. A practitioner in a nonprofit organization should understand the laws that govern donors and recipients. A practitioner in a particular industry, such as chemicals, computers, banking, or sports, should understand the laws germane to that particular area. That concludes today's presentation. While the laws affecting public relations can be very complicated, hopefully now you at least understand the basics and will be able to spot a potential legal pitfall before you find yourself in a situation like Lafayette College. If you have any questions, send me an email at mark.grabowski@marist.edu. Once again, that's mark.grabowski@marist.edu. Thanks for watching.